Well, hello everybody, and welcome in to another video here that should be interesting. Some very interesting content to get through, and I apologize for a little bit of a technical problem at the beginning. We are trying something new for the first time ever, streaming on Instagram live at the same time. So if you're viewing in from Instagram, let me know in the comments, and I appreciate it. Sorry if anybody got disconnected. I am going to, John, it's saying they're having trouble streaming to the destination on Instagram. So if you could check that out. So maybe we're not streaming on Instagram right now and it's all for naught. But if you got booted, I apologize. I hit the stream button, it went away. Now we're back. So if you can't watch it now and you're part of the rewatch crew and you missed this live, I apologize. I am going to get to it here in about one more minute. We'll talk a little bit about the channel, a little bit about videos coming up, and then we will get started. But John, I don't know if you were here when I said it is not streaming on Instagram, so you've got to fix that link up. So I got over 100 likes to a 6-second YouTube video. That must have been the other one because I don't think this one has 100 likes on it yet. So thank you, Stephanie. And if you hit the like on the other one, hit the like on this one. Sorry about that, guys. Whenever we try new things, there are things that happen, but we try to make it accessible for everybody as much as possible. And Cheryl, I saw that you posted a super chat in the other one asking if I got the cookies in the letter you left. Yes, I did. We're going to post a picture of that letter on our social media. If it hasn't been posted already, I had like a little, maybe we'll do a little boomerang or whatever of that. Very cool. Very nice words. I have a nurse from the area that watches the channel. That's awesome. So I appreciate everybody that's trickling in here from the other video. A couple things happening. We did a Daybell Vallow short that's going to post on social media and on YouTube at Tragos Law. If you don't follow us here, go ahead and follow us, talking about the new trial date. I recorded Ben Chu's response to all the amicus briefs that were filed on Amber Heard's behalf. That's posting tomorrow, so don't miss that. If you're not subscribed already, hit the subscribe button and the notification button. And then I just got finished watching the Alec Murdaugh hearing. And I want to know in the chat, if you guys are interested in the Alec Murdaugh case, let me know in the chat. And I'll make sure to do a video on it. It was actually really, really interesting. But you're all here for Courtney Clenney, and the OnlyFans model who has been charged with murdering her boyfriend at the time, or ex-boyfriend, whatever he was. And there's been some hearings, and we haven't gotten a ton from the trial, but they've been requesting bail. They've done it multiple times. They're saying she's not a threat to the community. They're saying that the evidence against her is great. The probability of guilt is great. That's what the state is arguing. The defense argues against that. We're going to have two different forms of media today, which is usually the best way to teach, they say. It's what I always try to do in my closing arguments, to have multiple forms. We are going to read the judge's order, and then we're also going to watch the video after the judge's order, where the defense attorneys make more arguments that there are some things that are not true, and perception is not reality when it comes to these influencers sometimes. And the court is taking that into account incorrectly and making their ruling to see if they can flip the judge's ruling before the final decision is made on whether or not she can get bail, home detention, inpatient treatment, just something to get her out of prison. So what we learn when we get the judge's order in a case where they're asking about whether or not there should be bail is we get a view on how the judge views this case, how the judge views the evidence in this case, whether or not the judge thinks the defendant is credible, whether or not the judge thinks any experts that have given testimony are credible, whether or not they think the defendant is dangerous. So it's really, really interesting because you get a very early view into the judge's mind when we see an order like this, and the judge let us know exactly what she thinks in this order. Usually we have to wait till sentencing in most cases that we viewed here together because we haven't been involved this early on. But here we have this early indication of exactly how the court feels about Courtney Clenney and the evidence against her. All right, so let's get to it here. All right, order denying release. So we have the answer, but let's get the reasoning and let's hear what the court says. This matter came before the court November 17th. Ordering a judge, defendant shall continue to be held without bond pending trial. Okay, so we know that's the answer. That's the ultimate answer prior to this hearing, because the defense does try to flip this one more time. But let's get a little look into what Florida law is and why the judge made this decision. In Florida, a defendant with an offense punishable by life imprisonment whose guilt is evident has no substantive right to a pretrial release, providing a substantive right to pretrial release with reasonable conditions unless charged with a capital offense or an offense punishable by life imprisonment and the proof of guilt is evident or presumption of guilt is great. In this case, the defendant is charged with an offense punishable by life imprisonment. Defendant's guilt is evident and the presumption of her guilt is great. To this court, the meaning of the phrases evident proof and great presumption of guilt have always been ambiguous. So if you're reading this and you're like, what does that even mean? What does evident proof and great presumption of guilt means? Well, the court agrees with you. That's kind of vague, but let's hear how the court makes this decision. The language in this state, and this is important, this is how lawyers work, how judges work, this is how law works. If you're not sure what something means, there are cases that define it, where other judges have applied this rule, and it helps you understand how this works. So when we look at a statute, we don't just have to look at the words and look at our interpretation, but we can go to how other lawyers, how other judges, and usually other judges' decisions are based on what other lawyers have argued in the past. So we can see how people have looked at these same words, how they've made these arguments, and usually a judge will make the same decision as a judge that has made it in a prior similar situation. So this court does that. They look at a 1992 case, and it gives some guidance to trial courts to determine whether the state has met its burden in an Arthur hearing, which is when we're talking about whether or not they should be denied bail. Where the state's evidence, although not insufficient to convict for a capital or life offense, is arguably impeached in substantial respects by other evidence, or is rendered doubtful by substantial contradictions and discrepancies in the state's case, the proof is not stronger than beyond a reasonable doubt, and accordingly, the accused is entitled to pretrial bail as a matter of right for such offense. So what is this saying? This is saying if there's not sufficient evidence to convict, if the evidence is impeached, if it's doubtful, if there are discrepancies and contradictions in the state's evidence, and the state doesn't have really that strong of a case, it's not a hook, line, and sinker kind of case, then this defendant should not be behind bars. Their life and liberty should not be impeded while they wait their day in court and are, in fact, presumed innocent. Because even the defendants, like Courtney Clenney, who's being denied bail here, she is still presumed innocent. But that doesn't mean that the court won't look at the evidence against her to see how strong it is when determining whether or not she should get out. The court does not believe, and this is this court now, the court does not believe the state's evidence in this case was rendered doubtful by substantial contradictions or discrepancies during this Arthur hearing. So when they presented the evidence, they heard the testimony, they saw pictures, saw text messages, heard from experts, heard from law enforcement agents. The court heard all this evidence at this Arthur hearing, and they didn't feel like there was doubtful evidence. They didn't feel like there was contradictions or discrepancies in the state's evidence against Courtney Clenney. There is no dispute in this case that the defendant killed the victim. The only factual issue in dispute is whether the defendant was acting in self-defense and whether this claim rendered the state's evidence doubtful. Clearly, the defendant and victim had a sadly volatile relationship. We can all agree there. And the judge is playing juror right now. The judge looks at the facts and they're making a determination. Is this evidence credible? Is it consistent? Is it great? They're making that call here. So we're already seeing the first juror look at this case. So we're getting an idea of how is a jury going to look at this case. Now, they're not going to be exactly like the judge and have the judge's experience, obviously. But this is important. We learn a lot here. There is ample evidence of communication in the form of texts, videos, letters, and audio recordings of how unhealthy their relationship was. However, From the evidence presented during this hearing, the court does not find the defendant's claim of self-defense on April 3rd, 2022 credible. So maybe it was bad before, maybe he was abusive before, but on April 3rd, 2022, the judge does not find that argument of self-defense credible. Now, the defendant doesn't testify. The defendant didn't get to put on a lot of evidence that they could put on at trial. So a lot can still change before it gets in front of a jury. But from what this judge has seen, which is a lot, she does not find the self-defense argument credible. Therefore, this claim does not render doubtful the state's case. Defendant's statement to police about her involvement in the victim's death is not supported by other evidence from the hearing, meaning the defendant's statement actually has contradictions with other evidence and is not found to be credible. The defendant's version of how the victim's stab wound occurred is not supported by the evidence, and we've been over this a few times with that expert testimony that we heard about. In her statement, she stated she threw the knife at the victim from 10 feet away in the defendant's interview. However, the medical examiner testified that the victim killed by a knife wound that went down into the soft tissue and into the muscle and injured the subclavian artery. He went on to testify that the victim's stab wound was 8 centimeters deep and traveled from front to back in a slightly downward trajectory. The medical examiner opined that at least 8 to 12 pounds of pressure would have been used to penetrate the skin and the muscle into the artery itself. So 8 pounds of pressure. That's not just throwing it across the room. When asked whether the victim's stab wound could have been caused by a throwing knife, the medical examiner answered no. It could not. Pretty wild. To a reasonable degree of probably scientific or medical probability. That's the standard here that they would be testifying under. The defendant's speculation over whether the knife could have been pushed in when either victim or defendant was trying to remove it is not persuasive. So the defense made an alternative argument. Either it was thrown or it was thrown and that's how it got stuck in there and then they were wrestling and it got pushed in while they were, grappling with each other. The judge did not find that persuasive. Will a jury? Who knows? Additionally, defendant's contention that she grabbed the knife only to scare the defendant and threw it at him with no intention of injury is undermined by the fact, and this is a smoking gun here, the fact that the defendant had intentionally cut or stabbed the victim twice in the 6 months leading up to the incident. You think that weighed heavy on the judge's mind? Will this come in at trial? It's a good question. I think it's definitely probative since the judge used it here, but is it too prejudicial? Other bad acts? Is it similar enough? That's something I expect we have in a Williams rule hearing at some point. On October 8th, 2021, the defendant stabbed the victim in his leg. On January 30th, 2022, the defendant cut the victim in the face, causing multiple lacerations which required stitches. Defendant clearly had no fear of using a knife as a weapon within close proximity to the victim, and there are no allegations that a thrown knife caused those injuries. The judge is like, you've done this before. You've stabbed him before. You've cut him before. You weren't scared to do it. He was injured and had stitches before, and the evidence shows you did it again here. Although the defendant claims the victim held her down by the neck at some point prior to the incident, there's no physical evidence of this. Her description of this event changed slightly each time she explained it to the police, making the statement less credible. The judge thinks the defendant lied when talking to the police based on the inconsistencies in her description. We talk about this stuff. We talk about how we would evaluate it. You as a juror, me as a lawyer. This is a judge evaluating it very similarly to how we have in other cases and how many of us have in this case as well. Photos and videos showed that the only significant bruises were there prior to the incident, as was the damage to her fingernails. That's where we looked at that dancing video with her dog. She had bruises on her legs already. So the judge saw that evidence and said, I think this was here before. Evidence clearly shows that the defendant was on the phone with her mother during some portion, if not all, of this incident. However, during a 20-minute recorded interview with police, defendant's mother never once mentioned that there was any physical violence or verbal threats from the victim towards the defendant on that day. So she was talking to her mom this whole time, and her mom never even said that she heard any threats or any violence or anything that she would need to defend herself in. Defendant's mother says that she heard yelling, that the defendant told the victim to leave, but never once does she say the defendant was in fear that day of being harmed in any way. Immediately after the incident, defendant's mother texts the daughter not to speak to police without an attorney, describing the incident as defense. However, when asked by the police whether she heard her daughter say anything that day, specifically whether she heard any threats from the victim toward the defendant's mother says nothing. She does not tell police of any verbal threats to the defendant or a physical attack by that victim. At this point, evidence of the defendant's use of self-defense on April 3rd, 2022 is not credible. Based upon the evidence from this hearing, the court does not believe the state's evidence was rendered doubtful by substantial contradictions or discrepancies shown by the defense. Therefore, the court finds that the state has met its burden of showing that proof of defendant's guilt is evident. So we don't know what it means specifically, but this feels like enough, is what the judge is saying. The court finds that there are no release conditions that this court believes can assure the appearance of the defendant at future hearings and or to protect the safety of the community. I think it's a little eye-rolly to say that she's really a danger to the community. But the fact that she may not show up, no matter the release conditions, we'll get to why that is actually a great argument for the state. And this is why your past can really hurt you. If you make bad decisions, they can follow you forever. Defendant has no ties to Florida and ample means to leave the country were she choose to do so. The defendant has substantial funds at her disposal. We know where those funds come from, right? And the ability to make more outside of the jurisdiction of the United States. We know how she would do that, right? This is the OnlyFans model case. OnlyFans models can make money anywhere, and a lot of it. Now, it says already that she has substantial funds at her disposal, and we'll see what the defense attorneys say about that. The state is correct. The defendant's criminal history in previous cases, this is what I'm talking about, her past, shows the defendant did not abide by her terms of her pretrial release conditions. She probably thought it was no big deal. She'd blow them off, whatever. Well, it's a big deal. Because while those other cases may not have been that big of a deal, blowing off your conditions of release there is now evidence that you would likely do the same thing here, especially when you're looking at a much more severe punishment than you were back then. At the very least, picking up new cases when out on bond. So she also picked up new cases when she was out on bond in the past. In those cases, the defendant was facing little jail time and still did not abide by the court's orders. The argument that we've heard in other cases, did she think she was above the law? Too good for this. Didn't have to show up. And maybe they were minor offenses before, but this is major and it's coming back to haunt her. The court is concerned about what defendant might do when faced with the possibility of life in prison. The court does not agree that placing the defendant on house arrest with her parents in Texas is an appropriate form of release in this case. This finding does not end our inquiry because the state filed a motion for pretrial detention, meaning they think the opposite. They think she's so bad that she needs to be detained before trial. They expressly authorized the court to order pretrial detention if it finds a substantial probability based on the defendant's past and present patterns of behavior, the criteria of Section 903046, and any other relevant facts the defendant poses a threat of harm to the community. In this case, there are several factors that demonstrate the defendant's threat of harm to the community and the need of pretrial detention, as noted above. The defendant has no ties to the state of Florida. This court has considered the nature and circumstances of the offense charged, and as stated above, the defendant is facing an offense punishable by life, namely second-degree murder. Court makes the following findings. This is important because the court is finding this. Defendant is charged with a dangerous crime as defined in Florida. There is a substantial probability that the defendant committed this offense, and the court has considered all relevant evidence as stated above in its findings. So the court thinks there's substantial probability already that the defendant has committed this offense. That's big. The factual circumstances of this crime indicate a disregard for the safety of the community. Okay. There are no release conditions which this court believes can assure the safety of the community, and the defendant poses a significant risk of flight for the reasons stated above. Therefore, the motion for pretrial detention is granted. So denied bail, granted pretrial detention means Clenney's not going anywhere. She's going to be sitting in prison until this trial happens. So I'm going to answer a few questions here, and then we will get to the actual hearing that happened recently. It's only like 7 minutes total. So a lot of you saying yes on the Murdaugh case. All right. It is very interesting what's going on there. I think we are live on Instagram now. John just told me. So if you're joining us from Instagram, it's our first ever Instagram live going through the streaming services. So welcome. We're planning on doing a lot more of that. If any of you want to jump on Instagram, it's @TragosLaw is our handle. Put in the comments if you're watching from Instagram, because we're going to see, how viable this is and how much interaction we get from Instagram, because that's what we love here. We love the interaction. Hit that like button. Subscribe on YouTube if you haven't already. So yeah, I appreciate everybody joining on here. I apologize for the technical issues in the beginning. Let's see here. Barbara, can they bring in people from both the victims and the defendant's past relationships to show or not show any previous DV? It depends on if you can usually bring in a case like this for the victim, some evidence that the victim was the aggressor. Now, how far they'll let them go into their past relationships, we'll see what the evidence actually looks like and how similar it is to this case, how close in time it is to this case, because there's a lot of steps you have to go through before you get these other bad acts to come in. Let's see here. People are saying she's pregnant. I have no idea. I did not think that she was pregnant. Oh, Elizabeth Holmes is pregnant. We're talking about all sorts of different cases in here, I guess. Radiant Sadum, a 6 centimeter stab from front to back and a descending blow. And she does have prior history of using a knife as a weapon in close circumstances. So it's not looking good. If the jury puts this puzzle together like the judge, she's getting convicted. A lot of people are saying, I don't buy this story. Yes, she has stabbed him before. People are asking if you heard that right. Yes. Bodie, I don't think she's a threat to the public, but I do think she could very well split 100% in lockstep with you. She was a threat to this guy for sure. And if I was his friend, I would have been like, buddy, you need to run. But I don't see her as a threat to the community personally, but I absolutely see her as a flight risk based on what she did in other cases, based on the amount of money she either has or could make in literally the blink of an eye, from anywhere in the world. See if there's any more questions. Patty L is a new member. What's up, Patty? Perfect time to join. We're going to do a fun member video here soon. Francine, aloha, from one of my favorite states. Emma is also a new member. Awesome. We love the new members. Thank you, Kathy, for the super sticker. And Andrea, thank you for the super sticker. Let me get the hearing video queued up here. All right. So let's watch what the defense attorneys have to say in their last-ditch effort to try to get her. We'll put it on 1.25 speed. I will tell you, too, before we get this started, the judge is impossibly low and very difficult to hear. She reiterates a lot of what she already said in her order, which I've read. I will try to repeat it if I can, but we'll listen to it together and just know when she comes on the screen, it's going to be hard to hear. Let me know how the sound is. I have to put my trash can outside the cleaning ladies here. So here we go. Hold on one second. Here we go.
Kathleen Hill, on behalf of the state of Florida, Mr. Sean Abendhoff has to be at another court during the sentencing matter, but he is also a member of that team.
And good morning, Philip. On behalf of the state of Florida.
Yes, good morning, Judge. Frank, on behalf of Courtney Clenney, F22-14137.
It's ready for Lucy.
Judge Larry Hanford on behalf of the Southern family who's present before the court.
So there is an attorney here on behalf of the victim's family standing up next to the state attorney's office. The defense attorney apologizes for being late because he was in federal court. federal court, as we say, big boy court, sometimes takes precedent over state court. So the state court's got to wait. Judges hate that, but they know how it is. So. She's basically just saying you filed this motion, it's denied, pretrial detention is granted. You will be able to hear some of the arguments from the lawyer. That's what I want to focus on. And then we'll focus on Clenney's reaction at the end.
And Judge, Your Honor said order state's motion for pretrial release. It's pretrial detention. Thank you.
Judge, I apologize for running late this morning. It says before I was stuck in federal court. I did have a brief moment to review Your Honor's order. I just wanted to point out, I think on page 4 of Your Honor's ruling, you indicated that the defendant had ample means to leave the jurisdiction. However, I think that was negated by the bank records and the testimony of Mr. Clenney. The court indicated.
So what does he say in open court and on the record? The court says she has ample funds. I think the bank records, that's proof. And then also testimony from, I believe, her father, Mr. Clenney. It's not true. She does not have a lot of money. However, the court's no dummy. And she knows, today's day and age, I hope she knows at least, you can turn that faucet back on and she may even be more famous now. And people may be more interested in her OnlyFans page now than they were before. She's got the name, the followers. In the snap of a finger, she could start working again. And you're not like precluded from doing that. If she was allowed to be released, even if it's on house arrest or at her parents' house, I mean, in an treatment facility, which we'll hear a little bit about, she'd be able to turn that faucet back on and start making a lot of money and then become a flight risk.
Millions of dollars at her disposal and the ability to make money outside the jurisdiction. But the testimony was that her contract has been canceled. She's not working. And her
contracts have been canceled and she's not working. I'll just tell you right now, I ain't got a contract with anybody. She just can flip open a, Courtney Clenney charged murderer. Maybe she will not get the same sponsorships, but she could open up an OnlyFans page right now. She can start a YouTube channel right now, an Instagram page right now, and make money.
Money's been used for attorney's fees, the home purchase, and she basically is bereft of any kind of funds that would allow her to survive outside of the jurisdiction.
She's basically spent her money on buying a house and paying for lawyers, is what he's saying, and that may very well be true, but it doesn't mean she can't make more. And how much does it really cost to flee? Have you ever thought about that? What's a one-way ticket cost? What's it cost to rent a boat or pay somebody to take you on a boat somewhere that won't extradite you? Not millions of dollars.
The issue, all those cases that Your Honor cited that she did not comport with orders of release for the Las Vegas misdemeanor, all these cases were dismissed. And we know at least in this jurisdiction, it's commonplace that if an offender picks up a new charge, no bond, and if that charge is no action or dismissed, generally there's a return to the previous bond conditions. We're just.
And again, he said just what I expected. Those other cases, like in Las Vegas, those charges were dismissed. They were no big deal. Maybe she shouldn't have even gotten arrested. So the fact that she didn't comply with those release requirements is literally no big deal. No big deal, Judge. You shouldn't hold that against her. But I think the judge is right. It tells something about someone's character when a court of law tells you to do something and you disregard it. Now, this very well could be her lawyer's fault. And she could have gotten bad advice from counsel saying, you don't need to do this, you don't need to do that. And now it's being held against her.
Just want to point out some of the issues that we're having. We'll consult together as co-counsel and decide where we go from here. But obviously, we for the record, object to Your Honor's ruling, and see where we go.
The only thing I also wanted to point out was Your Honor stated that you didn't feel comfortable having her released on house arrest to her parents in Texas. There is a potential alternative.
It's funny, lawyers, right? So the female lawyer very smartly says, Judge, it says here that you're not comfortable with her being released to her parents' house on house arrest. Well, let me provide you with an alternative spot where she can be released. And they're about to talk about a treatment center. But it's funny because the judge also said no release conditions would be appropriate because she is a flight risk, because she is a danger to the community.
That we did look into. There is an inpatient treatment program in Boca. It's called Karen Mental Health. We've spoken with the administrator there. It is a 10-bed, 60-day inpatient program. They often work with courts on release conditions. She could be released on home confinement there with electronic monitoring, ensuring that she stays in this jurisdiction nearby. She's monitored by the Miami-Dade Community Corrections Department on home confinement, and would, I think, hopefully alleviate some of the court's concerns. So I don't have the program here today to be able to speak to you, but
A good lawyer has options. These good lawyers know a treatment program. They can get her in. That treatment facility works with courts. They work with bond conditions. It wouldn't be a problem. We have this as an opportunity. They are doing everything they can for their client here to get her released. So this is absolutely not on the lawyers. This is on prior bad acts. This is on the judge and the state and the evidence against her and the statements already made by the defendant that were not found to be credible in the way that she explained the event. This is not on the lawyering, because they really did give it everything they've got to try to get her out one way or the other, and the court just wasn't going to allow it.
could arrange another date where we bring in the administrator to answer any questions or concerns the court has. But like I said, we did speak to them, and they did say they were willing to accept her into the program.
Judge, I don't believe it requires response. There are no conditions that will ensure her presence and the safety of the community. And we disagree with any release to any inpatient.
Do you know what that response tells me? From the state, he's like, Judge, there's no response. No conditions are going to work for this case. He already knows he's won. He knows this judge. He probably practices in front of this judge. Most of the prosecutors, in case you don't know this, prosecutors and public defenders, most of the time are assigned to a certain courtroom and a certain judge. So all of their cases are in front of the same judge. So they get to know how a judge rules on things, whether or not a judge is ever going to make an order like this, a written order, and then the defense attorney is going to come say three things and the judge change your mind. Maybe some judges, but most judges are not. Seems like he's pretty confident the judge is going to stick to her ruling. And he's right, because he barely even responded to it.
I don't think that any form of house arrest, especially with an inpatient facility, is going to alleviate my own concerns about her ability to leave the jurisdiction, whether it's millions, whether it's business, any funds that have not motivated. I think she's so I understand what your concerns are. You can absolutely agree to file these
I believe we have something today.
She basically said no, in case you couldn't hear her. And then we're not going to really hear much. The attorney for the victim's family says, thank you, Judge, for letting me be here. And then let's just take a look here without sound of Clenney's reaction to the court's ruling here. Thank you, Z Martin, for the super sticker. So she's being told basically it ain't happening. We tried the treatment facility. We tried your parents' house. We tried everything we could. Judge said no. And I'll tell you, it's very stressful for clients a lot of times. And they sit there and sometimes they hear what the judge says, but they don't understand it. I've had verdicts read where we got a great verdict for the client. And the client's like, what does this mean? Did we win or did we lose? You know, it's like, it's very stressful. A lot of lawyers speak throughout. So they're explaining to her now, it's not happening. And you get yourself in these situations sometimes with bad decisions. I understand that, but it is sad. I mean, Christmas is coming, the holidays, not to be with family, to be in prison. It does suck. No doubt about that. So yeah, she said that sucks, I think is what her lips, I just read her lips. We've got some good questions here I want to get to. Little Redbird Love is joining the membership crew. Love it. More the merrier here. It's going to be fun discussion here soon. All right. So that's the end of that very quick hearing. The judge did not change her mind. Not surprising at all. If you have questions, get them in here now. We're going to do about 10 minutes of Q&A before we go. Ann McCord asked, will this be televised? It seems like the answer is yes to that. All of the hearings, the motion hearings have been televised. Pooh Bear, is a flight risk decisions really contingent on her money? And then Pooh Bear also said, I feel her financial standing is irrelevant for the flight risk issue. If SO, I don't know what SO is. If someone is going to go, they're going to go. I agree with you generally, but people are more of a flight risk the more money they have. Because if you're going to fly to some foreign country with no money, yes, it could happen and you could get it done and you could be, resolute enough to make it happen. But if you're super rich and you fly to a foreign country, you could live like a king in a lot of countries with not a lot of money, makes you more of a flight risk. So it is part of the equation. It is not the only part of the equation. What if a potential juror heard the judge's thoughts? Surely this judgment shouldn't be public. Well, a couple things. People said it's really not sad, Peter. She killed this man. The family never see him again. She's not convicted yet. Okay, so I do believe in the presumption of innocence, but I understand, and I'm not saying I feel bad for her. So first off, if a juror heard this ruling and this order by this court, they would absolutely be struck for cause. They would not be able to be on this jury. They would be out. If they've been watching these pretrial motions, if you're sitting in the chat here and you're in South Florida, you ain't going to be on this jury. And if the judge asks, the lawyers ask, you tell them, hey, I watched the lawyer, you tell them, I've been watching this case. I've been following this case. I've already heard a lot about it. I would not be a fair and unbiased juror in this case. Only if people have never heard anything that's going on, don't know how the judge feels, don't know how anybody feels in this case, should they be a juror on this case. So if you really know what the judge has already said, you can't be a juror on this case. Who was the man that was killed? Robo Steve said, what was his deal? It's her boyfriend. They were verbally abusive to each other. She says he abused her. There's an elevator video where she's punching him and kind of going at him. She has called the cops on him. He's called the cops on her. They've assaulted each other in the past. So they do have, like the judge said, a very sad and volatile relationship. All right. Bodie said, weird. So much depends on what judge you happen to get. Not only what judge you happen to get, what prosecutor you happen to get also makes a big difference. And in federal court, it's even more of a difference depending on the judge, because the judges are very different and they have so much power and control. Yeah, it's a good point, Ann Kirk. Obumseli won't see Christmas or New Year's either. It's a great point. Yes, she claimed self-defense in this case. Brianna, victim is Christian Obumseli, 27 years old. Yes. Is there proof he assaulted her? There are complaints to police. So I don't know what you mean by proof. I haven't seen a video or picture. She says some of the bruising is from her. So I'm saying what the accusations are. I should have said alleged abuse from both sides, and the judge called their volatile, sad relationship. So all right, let's see what else we got. This chick's going to get life. Yep. What decides federal or state? I'm confused. Thought this was state. This is state. I was just answering the question about it depends on what judge you get or prosecutor you get. It matters more in federal court, in my opinion, than state court. This is absolutely in state court, yes. And whether it's a federal question, federal courts can come and basically grab some cases that they want as long as there is a federal nexus to get there, but this is not one of them. Did they set a date? Gail asked. I haven't seen a date of like a trial or anything yet. I think she will probably want the trial to be next year, because that's the other thing. When you're not out on bond, the defendant usually pushes the trial to be much sooner. Rich Cat. I have a hard time even considering a self-defense scenario. She chose to call her mom and not just leave. Yeah, and she didn't even tell her mom that he was abusing her. I don't buy a lot of her argument, if I'm being honest. I don't know if all of the so somebody said February 6th is a trial date. Somebody said there's a hearing February 2nd. I'm not sure. Yeah, I'm not buying a lot of it as well. Based on the past, based on the medical examiner and the evidence, it's hard to believe it happened the way that she explained it happening. Michelle Abbott, I am not saying she deserves life before the trial. No. If she gets convicted of what she's accused of, then she deserves life. Next motion hearing is 2/6/23. Okay. So we've got a couple months here. It's not unusual. It's usually slower over the holidays, so that's not unusual here. I believe, Maddie Graham, this is a second-degree murder, so we're looking at life, not a death penalty case. Anne-Marie DeMaio, definitely he was a battered man, just based off the elevator video. We did a video breaking that down. You should go check it out on our playlists. He's definitely a battered man there. I have no idea what his, actions were or what he did to her, but he was definitely she definitely abused him in the relationship. We don't know the whole story yet, so I don't want to jump to conclusions, but I feel confident saying we have that video seeing her punch him and grab him and shove him. So feel confident in saying that's a fact. Whatever else happened, we don't know yet. And the murder stuff, we're still waiting to hear more evidence on that. All right. Abdul Hakim, do you think it's likely the prosecution can prove she wanted to kill? So I think it's second-degree murder, which is depraved heart murder. And I think they'll be able to prove enough of a intent to kill for second-degree murder. It seems like they have enough evidence for that, especially based on the way the knife wound went in. If it was actually a stabbing downward motion, that usually is different than accidental killing or even self-defense where somebody would throw a knife. All right. So we are about out of time here. Thank you for everyone that watched with us, all the questions that came in. We've got 1,200 people here watching. So hit that like button before we sign off. If you're watching on Instagram, let me know in the comments. And by hitting that like button, it's our first ever live stream on Instagram. So let me know there. We'll continue to do that in the future. I appreciate everybody who's joining us for this. Let me know if you want to see the Alec Murdaugh update as well. And make sure you check out the Ben Chu response to the amicus briefs filed on Amber Heard's behalf, because you won't want to miss that. It's pretty spicy. So appreciate you. Hit that like button and we'll talk later.